Well, to be respectful of everyone's time, I wanted to kick it off with a little intro of what today's call is about. For those of you who I haven't met with, I'm Danielle Williams. I'm the Northeast rep. I support affiliate owners from Virginia to Maine. And if you're not in my region, I'm still here to support you. So at the end of this call, I'm going to be sending out an email with a follow up. But today's call, we're focusing on internal contracts. I have Matthew Becker, who is a long-term affiliate owner. I'm a little biased though. I pulled him out from the Northeast. He's been a 10 plus affiliate owner in Pennsylvania, but he is joining us today on the West Coast. So it's a little earlier there for you, Matt. But Matt also is a founder of Gym Lawyers, which their goal is to support and be consultants to us as affiliate owners, both to educate us and help us prevent. I hear a big ring. Okay. Um, and help prevent problems. So if you're new to this space as an affiliate owner, or even if you've been a long-term affiliate owner, I've always recommend, and I've always had for myself, despite also being a lawyer myself, I've had someone in my corner who I can consult with and review all my contracts. So that's just a side note. But with that said, I'm also going to put in today's chat Matt's website as well as his Instagram handle, because his blog is very comprehensive. He has put out a ton of articles with a lot of great information, since he also is providing advice on not only business formation, but also on the internal contracts that we are going to dive in today, including waivers, staff, and membership agreements, which is a lot to cover in an hour. And then also if you're buying and selling a gym. And again, that's super broad. So today we will be focusing on those internal contracts, and he'll be presenting to us on that. But I want to encourage you all to put any questions that might be relevant at the time in the chat, or any questions at all. Feel free to interject if it's relevant. Otherwise, I'll be moderating the chat. I'll circle back. It looks like it's a pretty intimate crew of us today, so I want you to feel comfortable and make this more of a discussion as we're going through. At the end, if depending on how time goes, if you have some burning question that didn't come up, let's dive into it. We'll have hopefully a little time for a Q&A, as well as any feedback if you found this valuable. Any feedback on what you would like to dive into if we were to say do these calls regularly. So with that said, I'm going to hand the baton over to Matt, and just thank you to all of you for prioritizing this today. Thank you in advance, Matt, for your time, for being a great resource to all of us.
Yeah, well, sure. All right. Well, good morning and good afternoon to everybody. Thank you for that nice introduction. As she mentioned, my name is Matthew Becker. I am the owner of Gym Lawyers PLLC. Just as a really quick kind of like a little bit further background on what we do. We provide legal consulting to micro gyms across the US. So that would include CrossFit affiliates, just functional fitness gym, personal training, cheerleading, gymnastics, MMA, parkour, pickleball. So anything and everything involved really in the fitness industry, to just make sure that you guys are all operating your businesses in a legal manner. I am a practicing attorney, or I used to be in Pennsylvania. I'm still licensed there, but in order to be able to service gym owners across the US, we limit our services to three primary, so that we can actually offer some sort of benefit and value. One is education. Danielle mentioned there's a blog. We have numerous podcasts out there. We do webinars like this, so that gym owners, unfortunately, ignorance of the law is never a defense. So you can't just go in and say, well, I didn't know my state required that. So that's what we're here, is to make sure that the gym owners know that the laws exist, and how to sort of prepare yourselves to be compliant. The second service that we offer is just straight consulting. Again, you don't know what you don't know. And sometimes we just need to field general legal questions. Similar, for example, I got one this morning that said, I had a coach who slept with one of the co-owners of the gym, and my other coaches don't want anything to do with her. So if we keep her on, would that be considered a hostile work environment? That's a fantastic legal question, and that's one that we need to look up because California, if you don't know, has some of the strictest employment laws across the US. So we have to be very specific in what we can tell the gym owner you can and cannot do so they don't walk themselves into a legal problem. The third prong of what we do is contract drafting. And so we represent gym owners in every stage of the gym owner process from just starting out from the point of view saying, hey, I'm ready to go. I want to open up an affiliate. What do I need to do? To established gym owners like yourselves who may have been in business for 3 months, 6 months, 10 years, and making sure that everything kind of stays up to date. Or maybe we haven't been up to date and we need to get up to date. And then, as Daniel mentioned, on the back end, we've got people looking to buy and sell and what we commonly refer to as M&A or mergers and acquisitions, and making sure that we do all of that stuff correctly. Okay. Today, we're going to dive into, start sharing my screen here. All right, we're going to dive into really the ins and outs of the three primary legal contracts you need as a gym owner. There are others, and I'm happy to express a little bit more or to explain a little bit more of what some of those other ones are in the end. But these are the three biggies, and the one that we want to make sure if we do nothing else, we probably need these three, okay? As a disclaimer, anything I talk about cannot be perceived as legal advice. You and I do not have a professional legal relationship. Every situation is always different. Even if I describe something that sounds exactly like your situation, there's probably some nuance that makes it a little bit different. So I'm just talking in general educational format here today. If you have specific questions applying to your gym, I can try to address some of them in the Q&A at the end, but ultimately I'm going to say, look, if we need to talk about your gym specifically, you really need to just reach out and set up a time so that we can talk privately, confidentially, and I can address your situation specifically. The three primary contracts we're going to talk about today are the liability waiver or waivers, depending on what sort of services you guys are offering, the membership agreement or contract or terms or payment conditions or whatever it is you want to call it, and staff agreements. Those two are going to be your primary independent contractor or employment agreement. Let's dive in with waivers. Okay. So it should not come as a surprise that at the very least, every gym absolutely needs a liability waiver. Presumably you all have insurance. And if you have insurance, your insurance is going to require you to have a waiver. The purpose is basically to protect you, provide that first layer of defense against a personal injury liability claim. Somebody comes in the gym, they're doing a bunch of muscle ups, the straps of the rings break, and they fall off and they hurt themselves. That's a personal injury. Somebody goes and does a box jump and they miss, and their shin comes down and nails the edge of that box and takes skin off, and they have to go to the hospital and get stitches. That's an injury. Okay. We run inherently dangerous activities at the gym, whether we want to call it that or not. Okay. And we need to protect ourselves against it. Okay. So the first thing that the liability waiver is designed to do is to protect you against liability claims, and it informs the member of the inherent risks that come into or that they are exposing themselves by walking into your facility. Okay, we can't sugarcoat this. Right? We don't want to say, well, you might be involved in an activity, but I'm not going to call it extreme. I'm not going to call it strenuous, because I don't want to scare people. The bottom line is in the liability waiver, if somebody says like, oh, wow, this seems pretty extreme, your liability waiver is doing a good job. Okay. We want to scare people through our liability. I mean, not directly, but we want them to understand what it is that they're exposing themselves to. Okay. The other thing we need to do in our liability waiver is we need to make sure that we're covering the different types of services that we're offering. Okay. All right, we need clear language. I was just mentioning outlining those risks. So, if you were like me when you started out your gym, I started out in 2013. It really wasn't. I didn't exist as a gym lawyer back then. There wasn't a whole lot of services directed toward gym owners. That was about the time that a lot of business consulting companies were coming out. There's like 321 Go Project and other specialized services were starting at that point to focus in on CrossFit gyms, affiliates, the micro gyms of that time. And so what we did was likely what other people do, which is now the big no-no, and that's going out online and just finding somebody's waiver that they've used, or if we left the gym and we went and opened up our own gym, stealing that waiver and just using it. And the number one problem that we have, aside from the fact that it's likely not going to give you the maximum amount of protection that you can get from a liability waiver, the number one problem that we see from any of those templated waivers out there is that it likely doesn't cover the service that you're actually trying to offer. Okay, so we need clear language that is going to outline the risks, and we put this in the top section of our waiver that's known as the acknowledgement of danger. Okay, literally, we are putting people on notice to acknowledge the danger that they are going to face by coming in and partaking in an activity. And so we look at different activities that people are doing within gyms. In one CrossFit gym, you might look and you might see group classes through CrossFit training. You might see personal training. Sometimes they'll offer yoga. We might have a cold plunge or a sauna, nutrition services, okay, at home, online programming. And each one of these services, each comes with it a different type of risk. Okay, a big one is also, if you have hybrid AF at your gym or some other 24/7 access, we now have a completely different type of liability that we've just exposed our gym to, known as premises liability. That necessitates a different acknowledgement of danger. And so the common problem that we see is, let's assume that the gym at least has an acknowledgement of danger that is beyond some general template they found online, but it only covers, say, their CrossFit group classes. Okay, it acknowledges things like you're going to run, you're going to lift weights, you're going to hang from bars, okay, you're going to jump on things, right? You might have a broken bone, a torn muscle, a pulled ligament, something like that, a concussion, rhabdomyolysis. Okay, we want all of that stuff in that acknowledgement of danger. But now, if we're going to add nutrition services are completely different. We don't have to worry about somebody breaking a bone, but we do have to worry about prescribing some sort of nutrition practice that could cause ulcers, could cause high blood pressure, could cause other stomach or heart problems, could cause allergic reactions. Okay, we don't know. And unless you're a dietitian or nutritionist, you're likely not going to understand a lot of what it is that you're prescribing for somebody and just eat meats and or what is it? Eat fruits and vegetables, nuts. Oh no, wait, I used to have it down so quickly. Eat meat and vegetables, nuts and seeds, some fruit, little starch, no sugar. I think that was close enough. Okay. Did I get it? All right. That could, even though that's like the prescription of fitness in 100 words, that could cause some people some issues. So now we may need a specific waiver directed toward nutrition, which is different if we're providing people with 24/7 access to the gym to just come in and do whatever they want. Now, I'm not telling you to deadlift. I haven't exposed myself to the liability because I'm telling you to deadlift. But now I'm taking on responsibility as the gym owner to make sure that my entire environment is safe because I don't know what's happening at 3 o'clock in the morning. And people have to acknowledge that unsupervised danger through the potential of a different waiver. Right? So that's one of the key elements that we're going to look for is the acknowledgement of danger. That will also go along with the assumption of risk and the acceptance of responsibility. And those are the three sections that I refer to as essentially the trio of danger. If you do not have those three sections in your waiver, you are not adequately placing the member on notice of what it is to be a member at your gym and the risks involved. The other sections of the waiver we need are a release of liability. People would say, oh, well, I have a waiver, so they've released liability. Well, 9 times out of 10, the waiver doesn't actually say that the member is waiving their right to bring legal claims against the gym for negligence. Okay, so we actually have to have that release language within the waiver. Again, we then need to add in an indemnification clause. This essentially says that if you bring an action against me as a gym owner and you lose, you now have to pay for all of my legal fees. You have to indemnify me from any harm as the gym owner that was brought forth by your claim that I injured you. Okay. And then something that may seem a bit obvious, but isn't always, is that we actually have to get signatures and dates on these documents from the clients. It is a bit of a shock sometimes when I get a phone call from a gym owner and says, somebody had a heart attack during Murph. What do I do? And I say, would you have a signed waiver? And they go, I can't find it, or I don't know, or no, it looks like somehow they got through the system and they never actually signed a waiver. That's a big deal. And so it's not enough just to have the waiver or to get some sort of a verbal acknowledgement of the waiver. We need actual signatures and we need dates on these that people are actually signing. Okay.
Um, Matt, I
Yeah,
had a
go ahead.
question. Can we
Mhm.
pause there? So in terms of covering different services, you had mentioned like nutrition. Are are there instances where you can lump them all together under one agreement or do an addendum? And can you elaborate a little bit more on that? Because I know
Yeah,
as owners we're trying to look for like the simplest one, and I
right.
think some of us might be even having to update our COVID-19 policies on our form. I just filled out a
Yeah,
waiver
yeah,
that
yeah.
seemed like an old one, but yeah.
Right. Yeah. And that kind of goes into the best practices, which is the final section here to talk about waivers. So great transition. We don't ideally we don't want to stick three different versions of a document in front of a client and say, okay, I need you to sign this, I need you to sign this, I need you to sign this. So but we also can't stuff a waiver full of a bunch of language that may or may not apply to that client or to that service. Okay, so there's a balancing act here of, can we be clear and understandable while also being lengthy? Okay. Length of an agreement does not necessarily dictate its legal enforceability, but having one without the necessary language, certainly, too short. If your waiver is 1 to 2 pages long, you're likely missing a ton of language in it then, and you're likely going to be exposed. But again, we don't want an 8 page long waiver with three different acknowledgments of danger applying to the three different services that you offer. So in order to get a little bit more clear about this, the way that we often look at it and say, okay, this is kicking in the need for an extra waiver, the clearest line for us really comes into play with, what are you selling as an individual service? Okay. So let me be a little bit more specific. Let's say at your gym, you offer CrossFit group training, personal training, nutrition counseling or coaching, and 24/7 access. Okay. If somebody can come into the gym and their only option is to sign up for CrossFit group class or personal training, and the nutrition coaching and 24/7 access are add-ons or just there and available because you offer like one universal unlimited membership, then it's best if we can stuff it all into one and just have them sign everything or just sign it all off into one, because it's going to apply to everybody that walks into your gym. However, if we're going to sell each one of those as an individual service, meaning I can walk in your gym and just do CrossFit or just do personal training or just hire you for nutrition counseling or just sign up for 24/7 access, that right then and there is now going to necessitate the need for three different waivers, because you need somebody signing up solely for nutrition to acknowledge only the dangers that come forth with nutrition. We don't need to worry about CrossFit or personal training, which typically all has the same acknowledgement of danger. And we don't need them to acknowledge premises liability because they're maybe not even be coming into your gym. Okay. So we don't want to stuff that waiver with inapplicable language, because that can come back to bite you as, well, this really caused a lot of confusion because I was signing a waiver that applied to a whole bunch of stuff I didn't even know I was partaking in. Okay. Um, so that's usually our bright line rule is what are you selling as individual services? But we do encounter gyms at times that say things like, well, I'm doing, another one I didn't talk about was like kids services. Danielle, you and I have talked about kids services in the past. Can I take my adult waiver that is applying to adult group CrossFit classes, and can I put it in front of a kid who legally cannot sign it and have a parent acknowledge it, even though it may or may not apply to my CrossFit Kids program? And our answer more often than not is no. It is not appropriate for you to use your adult waiver for your kids' programs. You need, again, this is a very specialized service, and you need a specialized waiver applying to that youth service. And it needs to be written entirely in the format of I'm the parent, guardian, or custodian, and I'm acknowledging that I'm exposing my minor child to an extremely strenuous activity that could cause all of these different types of injuries. And therefore, I'm waiving my right to sue the gym on behalf of my minor child. And it needs to be in that sort of tense throughout the entire waiver so that we actually know who the waiver is applying to and that it is directed toward that specific service. And that one's going to be a big one when people say, yes, I have adult group CrossFit and I have a CrossFit Kids program. It's very rarely that we don't instantly say you need two different waivers. The other best practices with your waivers here, besides, again, on that third one, ensuring that members sign the waiver, is make sure that you check for regular updates and reviews of your waiver. We've been at this Gym Large for about 3 years, and we have the version of the waiver that we started to use back when we first opened versus the version of the waiver that we use today. They are similar, but there's a lot of differences, because the services change. The exposure of liability changes. Okay. More and more gyms are having cameras. And so we need to be pumping in more and more language about the use of cameras, whether it's audio or visual. If you're in a two-party state, you need a two-party consent if you have cameras in your facility within your liability waivers. Otherwise, you could be invading people's privacies because they're not properly acknowledging the use of video and potentially audio within your facility. We now have to worry about copyrights. 5 years ago, we didn't worry about Instagram influencers and TikTok influencers, but now we do. And so if a member comes in and they've got some sort of booming Instagram presence, they may not want you using their pictures and their videos in your social media because they think there's some kind of value there. Well, we need them to waive that right. And so we need to pump that into the liability waiver. Service animals 3 years ago weren't a big deal. Now it's depending on certain states, again, California, Arizona, both pop into mind. We really have to be concerned about service animals, and we need to waive that in our liability waiver. Okay, so we always recommend at least once a year, you need to reach out to a legal professional to understand, have there been any updates in the law that necessitate adding additional language to your liability waiver? Danielle, I did not look at any of the questions. Are
Yep.
there any other questions involving waivers before we move on to contracts?
Yes, I was just going to interject. Aaron had a question about special needs
Mm-hmm.
and that
Um,
specific population.
was there a specific question, or she just said, what about people with special needs?
Aaron?
Yeah, so we have members with special needs,
Mm-hmm.
anywhere from Down syndrome to severe Down syndrome to and then just not as simple, but blind, autistic, etc. Is there need to be any additional clause? Is it like an in between adult and a kid waiver? Because the parent still pretty much is kind of, I mean, they're not quite obviously to the capacity mentally as an adult would, per se, but So I right now currently make sure I have their legal guardian also involved in the waiver. But does there need to be any additional anything else besides what I might already have between the adult and kid waivers?
Yeah, so first and foremost, it's really great to always have the guardian sign off, even if it seems like they're relatively high functioning. Still have a guardian sign off on it, and you can use your adult waiver. If the individual is over the age of 18, that's okay. You don't want a waiver that says like I'm acknowledging this on my minor child, but it's supposed to be applying to an adult. Okay, so you can use your adult waiver. We should have a section in there directly applicable to the fact that this waiver may be applying to somebody with special needs, and therefore the guardian is authorizing, or is signing off on their behalf. We should also then pump in some other acknowledgement of danger risks that are going to be directly applicable to perhaps their inability to go through a full range of motion, their inability to see anything. There is additional risks when we're working with a specialized class like that, and depending, if they're just being integrated into your groups, then we just need to update the acknowledgement of danger section a little bit to make sure it's included in there. If it's not, if you're doing a specialty class for them, then I would recommend a specialty waiver that is going to be very specific to what it is that you're doing with those individuals. Physical contact is another really big one whenever we're dealing with a special needs population that we want to make sure is in our liability waiver, is some acknowledgement that the coach, the trainer, the owner, whatever, is more than likely going to have physical contact with this individual. And we want the guardians to either say like, cool, or no, I don't want you to have any physical contact with them whatsoever. And therefore we need to know that, and we need to make other special arrangements. But otherwise, if they're just signing the waiver outright, it needs to confirm that, yeah, we're going to have physical contact with this individual, and it's going to be done in a professional manner, but you have to understand that it's going to happen.
One more quick question on the waiver note, just to make sure I'm covering all my bases. We also work with a couple of addiction recovery programs in town. And unfortunately, some of those programs, the cycle, it's like a revolving door as they come in and go out. That I know of, because we pay we are paid by the program, the recovery program, and they bring the athletes in. I don't know of any waiver, now that I'm thinking about it, that I actually ever have these individuals fill out that come in with this particular program. We just have an agreement and a waiver that was filled out with the program itself. Is that going to still be okay to cover this revolving door of individuals that come through? Is that an okay way of doing it?
Yeah. Yeah, and that's getting a little bit into the weeds, to where I'm kind of getting triggered with a "it depends" kind of an answer here.
We can wait.
I would recommend we dive into that more specifically, but with understanding nothing else, I would highly recommend that you have these individuals sign a waiver, because I'd love to look at the agreement that you have with this recovery center, but I'm willing to bet it does not cover some sort of personal injury liability that would accrue if somebody came in and injured themselves.
And I apologize. This is something that I should just set up a meeting with you. So I'll let you move on. Thank you.
Yeah, my pleasure. Okay. All right. Let's move on to membership agreements. As a caveat before we get into membership agreements, call them what you want. Okay. Again, we can every so often I'll say membership contract, and the gym owner like cringes, like, no. We don't make people sign up for a year in advance. That's fine. Anytime we are selling a service, we are forming some sort of a contract under the law. Whether that's a verbal contract or whether that's a written contract, your state is likely going to dictate that it has to be a written contract. You don't have to call it a membership contract. Just know that from a legal perspective, Anytime we are exchanging goods or money for services or products, we have formed a contract. Okay. So we can call it a membership agreement. We can call it terms and conditions. We can call it payment terms, contracts, call it whatever you want. Okay. The purpose here is really to set expectations of what you are going to do with people's money. Okay. We need to define terms and conditions of the membership, establish the rights and obligations of both parties. So you're paying me $50 a month for open access to my gym. That's the understanding. Okay. But we need to set other expectations, and we'll get into some of like the key elements of what you need in a membership agreement. And then the big one is state law compliance. Okay. And I'm going to cover this a little bit more, but one thing I want you to think about with your membership agreements, when I talk to gym owners about waivers, they understand the need for waivers because they understand that if somebody comes into your gym and gets injured and they sue you and you don't have a waiver, it's likely it's going to shut down your gym. Okay. Insurance is going to deny coverage. You're not going to have enough to cover the $500,000 judgment or the $50,000 settlement offer or whatever it is. So it's going to shut you down. What gym owners don't seem to understand or want to grasp is the similar need for a written membership agreement. Because if your state says that you have to have a written membership agreement and it has to have these terms involved, and you don't, and the state discovers it, they can shut you down. Okay, so different states have different levels of how much they enforce this stuff. Virginia by far is the top. Okay, if you're in Virginia and you are not registered with Virginia Health Club Act, they will track you down. Texas is getting pretty bad about it. Maryland's getting pretty bad about it. But then we have states like Tennessee and North Carolina that have health club acts, but don't seem to do a whole lot about it. And then there's only one or two states out there that really don't have any statutory requirement whatsoever for gyms and their agreements. All right, key terms and key elements within a membership agreement. Terms and renewal conditions. Oftentimes, and pay in fulls aren't super popular anymore. If you signed on with certain business consulting groups, they sometimes will recommend some sort of pay in full option where somebody's paying up front for 3 months, 6 months, a year. And we can talk about the pros and cons of paid in fulls, but usually we're just doing something like a month to month or an every 4-week renewal. We need to outline that within the membership agreement. We have to be very specific. If I sign up in the middle of the month, am I auto renewing on the first of every month or on the anniversary date or every 4 weeks? Okay. What are the fees? What are the payment terms? Okay. Are there fees associated with cancellation? Are there increased or decreased fees associated with something like if I do pay in full for longer periods of time? Sometimes 24/7 access gyms will do like a yearly registration fee or a maintenance fee. Okay, if those things apply, we need to make sure we're putting them all in writing. So we're setting expectations. More expectations we can set in writing with the member, the less likely, though nothing is ever a sure thing, the less likely we are to run into things like chargeback problems and refund requests and cancellation demands and everything else down the road. We need to be very specific about our cancellation and refund policies. I will say, never put anything in writing that you aren't prepared to enforce. 9 times out of 10, that is going to be my position. With refunds versus chargebacks, you can get me to move off that position a little bit, but we have to be very clear. What is your cancellation policy? Well, I have a 30-day cancellation policy. Great. So what happens if the member requests a cancellation 27 days before their next payment? Oh, I'm going to cancel them. Take the 30-day cancellation out of your membership agreement because you're not enforcing it. If there's no punishment for not getting outside of 30 days, take it out of your membership agreement. Similarly, if you have a 30-day notice of cancellation policy and somebody gives you 25 days notice and you're prepared to take that next monthly payment or that next 4-week payment, you need to tell them that, okay? And in order to then protect against chargebacks, you need authorization from the member to take that final payment. We could do another one on the completely on protecting against chargebacks, but just a quick note here. This is one of two places that most gym owners see chargeback issues, is sort of taking that final payment, if you will. And we can, till we're blue in the face, throw our written membership agreement at a credit card company to say, no, I told them I was going to take another payment. I told them I was going to take a final payment. And the credit card company is going to turn around and look at you and say, but the client did not authorize you to take that. You told them you were going to take it, but they didn't authorize you to take it. Well, we can now adjust membership contract language so that we can help support the claim that, yes, the client did authorize us to take that because we put it in writing and because we had the client actually sign that agreement. Okay. Holds and freeze policies. Do you permit them? How many times during a year? How long can the holds be? Is there a minimum and maximum time? Does it have to be in monthly increments because you sell monthly memberships? When does the hold start? Does it start at the time of request or at the time of the next payment? Okay. Are there exceptions to additional holds? Like we only allow one hold a year unless you have a medical issue supported by a doctor's note, and then we'll allow an additional hold each year. Are there fees associated with a hold? Okay, so trying to pump as much of this information into this written membership agreement as we possibly can so that we want to eliminate the potential of a client coming and saying, I want to put my membership on hold. What do I need to do? Okay, even though you and I both know they still do that. But if we can put it in writing, we can then say, yep, we require a 10-day notice. It needs to come to us via email. And if you want to check out the remainder of our terms and conditions, look at the signed membership agreement that you signed when you joined. Okay, because it's all laid out right there. Whoops, I went backwards. There we go. All right. So best practices with our membership agreements, ensuring clarity in terms and conditions. Again, we always want to be super clear up front. We're not trying to hide anything. Transparency sheets are great. If you ever have the hesitancy of like, maybe I don't want to tell them that, even though I want that to be my policy, rest assured you need to put that in the agreement. Okay. You include all relevant policies and procedures. I will often say include, if you have personal training and you have a 24-hour cancellation policy to cancel or reschedule a personal training session, and the threat is they will lose the session, stick that in your membership agreement. Okay. We want that to be there. We want that to be obvious because as soon as we try to dock somebody their $70 or $80 an hour personal training session, that's going to cause a problem if they don't know that you have a 24-hour cancellation policy. Even if you told them that's not enough, get it in writing. So that way it helps prevent them from coming back and saying, I didn't know. Keeping these agreements up to date as you bend and mold and change services and remove services and add services, you really need to be bringing updates now to your membership agreements. Okay. As gyms, another easy example, we started off as just offering CrossFit, but now we're offering 24/7 access. There's a bunch of terms that are probably going to apply to 24/7 access that we then need to make sure we are included in our membership agreement. So a yearly, every 6-month update is always recommended. There are also state laws change. We just saw New Jersey come out with, I think it was in April, they dropped a new law that says if you give the members the ability to sign up online, which isn't super common in our industry, but it does happen. You also have to give them the ability to cancel online, and you have to tell them in your membership agreement how they can go about doing that. They're the second state to institute something like that. And the first one was, it was either Iowa or Idaho. And I can't remember right off the top of my head which one. But we're getting more and more updates like that from state laws as things are more and more moving online. All right. Any questions about membership agreements before we move on to the final agreement, staff agreements?
I don't see any in the chat.
Okay. All right. If anybody wanted us to hop in. 3, 2, 1. All right. Moving on to staff agreements. Okay. Two primary staff agreements that we need to be concerned about are going to be employment agreements and independent contractor agreements. I would love to engage in the great debate of can we have independent contractors versus employees in the CrossFit realm, but I'm ultimately going to kick that over to your accountant. I could talk to you about it from a legal perspective, but from a tax designation perspective, that needs to go over to your your accountant. The bottom line is, regardless of what kind of staff we have in our facility, we need to put them on some sort of an agreement. Go back to our membership agreement. Think expectations. When we're dealing with employment, when we're dealing with independent contractors, we need to set those expectations, mainly around how are they going to get paid, right? That's the big question everybody wants to know is how am I going to get paid? Okay. Whenever we're talking about this distinction of employee versus an independent contractor, there are only a couple super bright line rules that are going to kick everybody over into employees. Otherwise, it's this constant swinging pendulum that looks at the amount of control we are exhibiting over the staff member to determine, are they employees? Are they contractors? At the very least, if you're going to have contractors, stick them on an independent contractor agreement. That does not guarantee the pendulum is going to automatically swing to independent contractor, but it's a really good start to support a claim if you're ever audited that this is actually an independent contractor. Okay, so big key elements of an employment agreement: defining the employee-employer relationship. Okay, and key elements here are going to be the job description. We're not going to explain how to do the job. That happens in your employee handbook. We're just going to explain what the job description actually is. For example, general manager, head coach, personal trainer, group coach. Okay, then we turn to our employee handbook, where we outline what it means to be a general manager, what it means to be the head coach. And then we layer on our standard operating procedures, where we explain step by step how to carry out the duties of the head coach, the general manager, the group coach, etc. Okay. Certifications. This is where we're going to set and have the employee acknowledge what kind of certifications are necessary for them to achieve employment or get continued employment. If we're all CrossFit affiliates, somebody at least has to be CrossFit level 1 in order for them to really work at the facility, whether they're an employee or an independent contractor. But in our employment agreement, we want to say that you are acknowledging that you are level 1 CrossFit trainer. Okay. Even though it's technically not a certification, they have a trainer's certificate. And we might then also say within the first year of your employment, you have to attain a CrossFit level 2 trainer certificate. We need to outline that as a requirement, as a condition of their employment in their employment agreement. What's the compensation? What's the benefits or lack thereof? What are their expected work hours? And what are their termination conditions? Okay, we want to be clear, and rarely am I going to suggest anything other than at will. But if we're going to have them at will, we sure is better say in our employment agreement they are at will. Okay. Finally, and also within the employment agreement, we need to include sections like non-solicitations, protection of confidential information, and unfortunately, whether we are looking at the new FTC regulations that are still waiting to be affirmed, or the fact that we're all CrossFit affiliates, we don't get non-competes. So we can just wipe those right out of our employment agreements, but we can still protect your gym through well-written non-solicitations, which basically says, if you're an employee and you leave my employee, you can't take all of my clients with you. And protection of confidential information, like the fact that my clients or the gym's clients' emails and addresses and phone numbers are all confidential. Our standard operating procedures are all confidential. The programming is all confidential. You can't take that confidential information and try to open up your own gym or go to another gym and try to take how we do everything. Now, we can turn to independent contractors. Again, we need to define this relationship because An independent contractor really needs to be looked at as a freelancer. Okay. How much control are we exhibiting over this individual? One of the big questions that I have for gym owners is this independent contractor free to work for another gym in your area? Okay. The answer should be yes, they are. Sometimes it's no, they aren't. And then we have to have a talk about, well, you could be exhibiting too much control over that person. So you really should reconsider that. Okay. They need to be freelancers. You are an independent contractor. You're self-employed, right? Nobody is telling you what you can and cannot do. You're oftentimes operating under your legal entity, your corporation, or your LLC. And so we might recommend that the independent contractors also need to have their own legal entities, because you would never hire an LLC, but you sure would bring in an LLC to perform a specialty service. So we need to know what their scope of work is, right? Again, what are their titles? What are they being brought in to do? If they're being brought in to be your general manager and you're trying to consider them an independent contractor, that's probably going to be a tough play. Okay. If we're just bringing them in to be an hourly coach, a little bit easier play, but we want to put that out into the agreement. Payment terms, contract duration, one of the factors for the IRS and oftentimes workers' comp and unemployment considerations are going to be, is there a definite term here? Or is this thing just open? So we'll often recommend that we put in our independent contractor agreement something like a 6-month or 1-year limitation. And yeah, okay, we're gonna renew it after next year, but that requires us to sit down and put a specific duration into this agreement. Insurance, big topic. So I said earlier, there's very few bright line rules that are going to automatically kick somebody over into that employment realm. Well, one of those bright line rules is benefits. Okay. If I give my staff member a medical benefits, medical insurance, they're automatically employee. If I pay for their level 1 as a perk of being on my staff, they're automatically an employee. If I give them paid time off, okay, they're automatically an employee. These are benefits. One that often falls under the radar is insurance, medical, or I'm sorry, not medical insurance, but liability insurance. So assume for a second you're coaching in my facility. I consider you an independent contractor. You're running my group class. You're in the middle of something. Somebody falls off the pull-up rig, lands on the box, hurts their back, sues the gym. You as the coach are probably going to get pulled into that lawsuit as well because you were the one running the class. If I all of a sudden call up my insurance company and say, hey, I consider that person an independent contractor, but you know what? Pull them in under my insurance. I just provided you a benefit. Okay. And that can then open up a can of worms of, did I just move you into a category of employment? And what are the issues that we have now? Okay. So for our independent contractors, great, we can call them independent contractors, but we really have to have a conversation of they really should be maintaining their own liability insurance. And then termination conditions. You really need to be able to, either party can terminate this agreement at any time for any reason. If you give them some sort of a disciplinary right, if you give them some sort of a right to like a 2-week notice before you can terminate them, you've probably just kicked them over into the employment realm. So you have to be very careful about how we define our termination rights for somebody who is considered an independent contractor. The key here is distinguishing them from an employee status.
Matt, I had a question.
Yeah.
And maybe someone else. I noticed a big dichotomy between each of those with the certification. And you had mentioned the liability, which can come up. So if they're an independent contractor, are you saying that we can't outline the requiring them to have an up-to-date certification? Or can you elaborate a little bit more?
Yeah, that's a great question. That was probably just a note that we didn't put in there for brevity's purposes,
Oh.
and I appreciate you pointing that out. But yes, you can make it a qualification in order to be an independent contractor at your gym that they do acquire and or maintain a certain level of certification. We have to be careful about making their continued work contingent on things, that starts to bring us into a gray area that is going to be very state specific and sometimes IRS specific, of saying things like, yes, I can say that you have to be CrossFit level 1 trainer certificate in order to be an independent contractor. But if I start saying things like, but continuing to be an independent contractor is going to require you to get your CrossFit level 2 trainer certificate, now we start to walk into a little bit of a gray area.
Okay.
Okay. Similarly, like we can require CPR certification. That's not going to be an issue. If we're going to pay for them to get certified, that's going to be an issue. Or reimburse them or split the cost. That's going to be an issue. Right? Okay, common elements here that we want to see in any staff agreement is clear job descriptions and expectations, compensation and benefit details, confidentiality and non-solicitation clauses, but not non-competes, termination conditions and notice periods, whether we're dealing with employees or independent contractors. And then sometimes we say, well, what about trading services? Am I allowed to say to somebody, well, I'll give you a free membership if you cover a few of my classes? That's doable. It's not great. It can be frowned upon. It's better to either just make it a perk of working for you, but you're still paying. Or 9 times out of 10, the way that we like to eliminate that is we say, especially if they're an independent contractor, the contractor will continue to pay for the membership, and then you will just pay them for all of the work that they complete. And if it washes out, it washes out. But we're still seeing that passing of money, and we can't be looked at as providing them a free membership as a benefit of working in our facility. Okay, guys. So quick overview on the 3 most common gym contracts. We're going a little bit long here. I'm happy to stay on a little bit longer if you guys are cool with it. But opening up right now to questions, we can talk about questions on things that we've covered. If you guys had another burning question in your head that didn't really deal with it, with what we talked about, that's fine. I can try to address that question as well. But feel free to unmute yourself, ask the question. We can go from there.
Okay. I'll start. I'll ask
yeah.
a question.
Go ahead, Aaron.
So in reference to, you had a interesting point, and I hadn't even thought about it, for the online signups. So, because that is, as you said, kind of the world is transitioning. Almost everything is online now.
Mm-hmm.
Currently how we are set up is if they want to come try a newbie class, so a free class, they can sign up via our website online. However, when they sign up, there's a waiver attached to it. They have to sign the waiver.
Mm-hmm.
I think when you talked about it was during the agreement, the membership agreement portal. Do I need to put something also in that first initial newbie class online, or is it all right if I do it afterwards? When they actually, there is an exchange of money when they actually sign up. That's when they do our membership agreement.
Right. If you're waiting until they're actually if they're just signing up for the newbie class, there's no exchange of money or anything, and all they're doing is signing a waiver. And then at some later point, maybe you're sitting down with them and saying, okay, these are our options, and do you want to sign up? And they say yes. And then they're actually signing up in person, and that's where they're signing your membership agreement. That's no problem at all. You don't necessarily need to then give them the option to cancel online. Okay.
Matt, I have a question.
Mhm.
What's the most common error, mistake that you see gym owners doing in regards to these 3 documents or things that they need to have in place? What are people missing most often?
Yeah. So the most common problem is finding something, templates, stealing something from somebody else, buying into a gym and then just using their agreements and assuming that it's okay, either because there's never been a problem, so why would there be a problem? or that it looks like it's okay, it sounds legal, so therefore it's going to cover me. Um, I would liken it to, just handing somebody a generalized fitness program. Somebody comes in and says, "Hey, I want to lose 10 pounds," and you say, "Great, here's my boilerplate 12-week spreadsheet. Go ahead and do this, and you'll be okay." Versus somebody comes in and says, "I want to lose 10 pounds," and you say, "Okay, great, but I'm going to have to give you some specialized, customized things in order for that to actually work for you." It's similar in that realm. The most common mistake is either not having anything or trying to use something that is just out there for the general pop and isn't actually customized to what it is that you are doing. I'll expand on that a little bit by saying the second biggest mistake is assuming that I've been in business for 10 years and haven't had a problem, so I don't need to update anything. The law is fluid, it changes, it moves. What applied a number of years ago does not necessarily apply today.
Thanks. Second question would be, in each individual state, obviously there's nuances, legal and all of that. What's the best way to be educated and informed about what our state or local governments require as well?
Yeah. Honestly, reaching out, and this isn't like some sort of like, I'm not going to give you the answer, call me, but reaching out to us because we know where to look for it is probably the most streamlined approach. Otherwise, turning to Google is going to be your best resource. If you don't know otherwise where to look for it, searching for something like Pennsylvania Health Club Act, okay, or Texas Health Spa Act. Just try to do some general Google searches that way. There's a lot of resources on our website that is going to let you guys know that this may potentially apply in your state and give you some of the tools that you can go out and be a little bit proactive to look it up on your own. It's just a matter of, can I change my own oil? Sure, I can. I can go on YouTube and spend the time learning to do it, or I can just go hire a professional and know that it gets done. That's, whatever your tolerance level is for DIY. The information is out there. Your best resources is start on Google.
Thanks, Matt. And you were extremely helpful when we had to renegotiate a new property management contract. So thanks. Yes. This was really great information.
Thank you, Carla. Appreciate the feedback. Thank you so much.
Those were great questions, Carla. I actually wrote down resource for state laws. Besides Google, actually, but Alexa, no.
Yeah, right. No, it really is like there's a lot of resources out there. Google, I will frown against something like ChatGPT just because, somebody who knows and I will go and run sort of preliminary researches on ChatGPT every so often just to check and it's not always it's right probably about 70% of the time. But being able to perform little searches like that, going to a blog, listening to our podcasts, and listening for buzzwords like the acknowledgement of danger, the acceptance of responsibility, the assumption of risk, and then being able to go and Google those things, you can start to educate yourself a little bit more on like what are these sections of a waiver, what are like the buzzwords to look up what my state requirements are, what is a surety bond, and then taking the time to do that research yourself. It is out there. Google is probably your best resource for it.
That's great. I was also going to ask Matt, do you have a free consult, like a 30-minute? I was looking on your site and I saw your email address, but what would that process look if I had an issue and I didn't know how it was going to escalate, but I wanted to just have a quick consult with you? Would that be free, or like how much of your time would that be?
Yeah, so I just put up thank you everybody for attending slide, and really my contact information right then and there. You can email me. That's my cell number. I joke that I do not hide from my clients. So if you want to text me, text me. It's right then and there. I will respond. And then just going to the website. If you go to the website, you can have the availability to sign up for a free 45-minute consultation. I have to be careful about giving, like the free 45 minutes. That doesn't mean like you come on and you say, like I gave the example earlier of like, I have this employment issue. What do I do with it? Because chances are I'm not going to know, and I have to go get that information. So the 45 minutes is typically meant as sort of more of a discovery call. If you have specific questions about, like I need to update my waiver, or did I set up my legal entity correctly, or I'm thinking about selling my gym. What do I need to do? We also have a legal audit service that during that 45 minutes, if for no other reason other than you just want to check up, I'll start at the beginning with your legal entity, and I'll look into all of it and tell you where your exposure is in that 45 minutes. Beyond that, if you are a client otherwise, we're pretty much just here and accessible. If not, and you want something beyond the 45 minutes, we do $75 30-minute consultations, where, again, this gives you now the ability to say things like, hey, I have a really specific question. Can I hire you to have a actual like legal advice consultation? And we'll gather the information that we need before the call. And so that way we can get on the call and actually have a productive, like, I'm giving you something that you can actually use going forward. We're not just going to get on there and then I say, okay, wait, let me go do the research and I'll get back to you.